Um, so yeah, if everyone could please take your seats and we will get started. No one cares about what I say, so I will just start talking before everyone gets seated. But I am so honored, and we are all honored to have Commissioner Rebecca Slaughter with us today. Um, she doesn't need an introduction, but I will give her one. She was sworn in at the FTC in 2018 and has been, a champion of promoting competition and consumer protection issues. She's been a leader, particularly on pharmaceutical issues, including on PBMs and drug pricing. She's also championed aggressive enforcement on healthcare mergers and has spoken out on specific consumer protection issues related to privacy enforcement in healthcare. I mean, we're going to get into some of this specifically. I think from my perspective, having watched the FTC for a long time, Commissioner Slaughter has really been a leader in and sort of a pioneer in her willingness to really dig in, learn the policy, the market issues, the nuance of how competition in specific markets works, the history of how that has evolved at a granular level that I think is relatively new. I don't think that was done for a long time, and also just an admirable trait for a commissioner to personally take on that level of interest in all of the decisions that she's making. And so please give her a warm welcome.
That was an incredibly generous introduction, Teddy. Thank you. I am humbled and flattered and really honored to be here and really excited to talk about the exciting and important work the FTC has been doing on healthcare issues across the spectrum.
And I think for first, just to kick things off, it would be great to get your take, as we wrap up the Biden administration, your take on the legacy of the administration when it comes to healthcare. There's just so much activity. We have a lot of people in this room worked on a lot of these issues. Would love to get your sense of what is the legacy that the Biden administration leaves behind at the FTC on healthcare.
Yeah, so I think it's important to start with the fact that an interest in healthcare is not new to the FTC. The agency has a long, really impressive history of closely scrutinizing hospital mergers, for example, anti competitive deals between branded and generic drug companies, and a whole spectrum of other issues. And where I think we have really had a great success under Chair Khan's leadership is taking that legacy and being able to build on it and expand it to be reflective of how competition is really presenting itself in markets today, and not just resting on how we have always looked at things. That's both an opportunity and also, I really think, our obligation. We should be fact oriented. We should listen to market participants. We should study markets carefully. And then where enforcement approaches need to evolve, we should do it. So I could, and I will, actually, I was going to say I could. I will rattle off a litany of some of the areas where I think we've made some really big innovative steps. So, for example, let's start with private equity roll-ups. That is a topic we've heard a lot about over the years, and it's something that we have closely scrutinized. We brought the first case against a private equity roll-up of healthcare practices in Texas. That's not the only area where this may be a problem, but it was pretty novel to have that case. And we've also done workshops about private equity in healthcare. So that's one area. We brought, when I was acting chair, we brought the first litigated vertical merger challenge in Illumina's acquisition of Grail. And that ultimately resulted in a unanimous Fifth Circuit decision upholding the commission's opinion challenging the acquisition. That was a really big deal. We have looked at the PBM industry very closely. Again, having heard about it for a long time, there's been a lot of bipartisan congressional interest. So we have been working on studying the industry closely. And if and where we find evidence of illegal conduct, doing investigations and bringing cases as appropriate. So we filed a suit against involving the PBM pricing practices, specifically around insulin. And I think we'll continue to scrutinize those markets very carefully. And then the last big innovative area that I want to talk about is the Orange Book challenges that we have done. That is new and different, and but builds on the legacy that the FTC started with some of its pay for delay cases that say just because a patent exists doesn't mean everything you do with the patent is legal. And the Orange Book cases in particular have resulted in companies delisting some patents and bringing down prices of things like inhalers and EpiPens. And that's really critical to ordinary people. The reason I think that this is really important is there is no one in America whose lives are not touched by healthcare in some respect. And so working throughout our agency to think about the ways in which healthcare markets are operating in ways that might violate the laws that we enforce or require more transparency is really important to people in their everyday lives. And so, like I said, this has been a long legacy that the FTC has had, but I'm really proud of the ways we have built on that legacy, and I hope and expect it to continue to grow.
I'd love to stay on pharmaceuticals for a moment before we get into what are the bipartisan issues that we see. You mentioned Orange Book, and the way I think about the hurdles in the pharmaceutical market. We've already talked a lot about PBMs. We can talk about that in a minute as well. But from a holistic standpoint, you have PBMs, you have these patent games like Orange Book, you have patent thickets. In order to return to a world where when there is a patent cliff, the price actually does go down, that there actually is a functioning generic market, do you think it requires what you at the FTC and the Biden administration have done, which is kind of this all of government approach to peeling back all the layers of that onion in terms of like restoring what you originally saw in Hatch-Waxman? Or is it even like, do you need legislation? What do you think is necessary to actually get back to a functioning, pharmaceutical market, and like, how close or far, do you think we are?
Yeah, so I think it's pretty much always true that complex problems may require complex solutions that involve multi players. It would be irresponsible for one agency of the government to tackle a problem where other agencies that touch the same problem are not coordinating and sort of rowing in the same direction. So I do think the all of government approach is really important and also a little obvious, right? It's surprising to me that it took that long to get there because there are so many operations of government that affect competition, and being blind to that doesn't mean it's not true. And so what I think President Biden did that I think is really important is say, actually, we are aware of the ways in which other arms of government affect competitive conditions in markets, and we are going to think about that in the implementation. I tend to think part of what your question framed was, should agencies do more or do we need legislation? And my answer to that question is almost always yes. It can be both things. Almost always where there is a persistent problem, legislative fixes will make it easier to solve them if they are well done. That's a big caveat because poorly done legislative fixes can actually entrench problems. And so I worked on the Hill for a very long time. I'm really sensitive to the fact that doing legislative fixes well is very hard and is not a reflection of the intent or effort of the people putting them together. It's just a very difficult project. So I think it's an important thing to do. And in the meantime, we should not be waiting around for Congress to fix things. We should use the tools that we have at our disposal to challenge problematic conduct where we see it. So, for example, of things I hadn't yet mentioned, the FTC brought our lawsuit against Martin Shkreli for his conduct involving the pricing of a generic drug that should have been and was very cheap. And he raised it astronomically, and it was the only drug that was available on the market to treat toxoplasmosis, a life-threatening condition. So not an optional tool for people. And that lawsuit resulted in litigated victories, really important opinions, a lifetime ban for Mr. Shkreli, and was an example of using all of our tools to challenge problematic conduct. Interestingly, in that case, I supported it. It was brought under the first Trump administration, but I thought we could have done more in that case. We brought it as under the traditional antitrust laws. I thought there was also really good grounds for an unfair acts or practices count. That's our traditionally consumer protection tools. Unfairness is statutorily defined as something that causes substantial injury that's not reasonably avoidable and not offset by countervailing benefits. And I thought the conduct in that case there was reason to believe that that law was violated by the conduct at issue in that investigation. An interesting note about the insulin suit that we filed is that it has one of those unfairness counts in it too, in addition to the competition counts. And so that is another area where I think we've seen growth in the FTC and thinking across the agency and using all of our tools to attack potentially illegal conduct.
And you mentioned already that the FTC has a long history of focusing on healthcare, I think in a bipartisan way as well. What do you think are some of the issues that are sort of the low-hanging fruit from a bipartisan standpoint on healthcare when it comes to healthcare?
Yeah, so I continue to think basically all of the things that I have talked about can and should be bipartisan, and I hope that they will be. There is concern across the aisles about abuse of market power by large players in healthcare markets, whether that is PBMs or pharmaceutical companies or hospital systems. We hear all the time from folks in Congress about these issues on both sides of the aisle, and I think that drumbeat will continue. And I think you've seen actually a lot of evolution in the current Republican Party and pushback with some concerns, particularly about pharma markets. And so it'll be really interesting to me to see what the follow through on that is. But my hope and expectation is that we will continue to build on this important work.
One area that, and then in a few minutes, I want to open up to questions, but that I think the FTC made a big statement on was pharmaceutical mergers. And there were specific types of mergers that I think were really, that the FTC really wanted to discourage. I was wondering if you could talk a little bit about the legacy when it comes to enforcement on pharmaceutical mergers, what you hope to see going forward there, and, the types of mergers that you saw and continue to think are the most problematic.
Yeah, this is another area where I think I'm really proud of the build. The FTC has investigated and addressed pharmaceutical mergers for a very long time, usually by identifying potential overlaps in products and pipeline products and requiring divestitures. The question that we have to ask always is, does that work? Is it enough? Is that promoting market entry, innovation, the availability of competing drugs to be on the market to help us drive prices down? And I think there were good reasons to say, I'm not sure that's working as well as it should be working. Are divested products really coming to market? Does that protect competition? If the number of potential acquirers for small, innovative pharmaceutical companies goes down because there is consolidation among the larger players, does that disincentivize investment in the first place because there are fewer potential acquirers and therefore fewer potential opportunities for exit? These are all really important questions to ask. It is also important to me that we think about what are the incentives specifically for the companies in making acquisitions, not how do lawyers back into that analysis at the end of the day, but who's making the decisions and why are they making those decisions, and understanding, therefore, what the likely result of the merger is going to be. So I mentioned that for a long time, the FTC had addressed these mergers. We had never outright challenged a pharmaceutical merger until a couple years ago. And we've had now a couple of challenges, including an abandonment in the Sanofi-Maze acquisition, a settlement in the Amgen Horizon acquisition. That's a real change in how we're thinking about these things. And what I think we want to continue, you asked about what do we want to incentivize going forward? So we want to incentivize more innovation, more entry, more competition in drugs on the market, with an understanding that in the pharmaceutical space, there's a lot of uncertainty when you're doing research and you're doing investment in the first instance. So there is no guarantee that a drug that goes to trial will end up going to market. And we have to look at whether acquirers are looking to actually bring drugs to market, or are they looking to potentially eliminate the possibility of competition from those drugs? Are they looking to potentially prevent a different competitor from bringing a drug to market? And so that's why, all of these issues are extremely fact specific, very law and fact intensive, and require detailed investigations. But we have to be asking, I think, the right questions in the first instance in order to do those, and then send a message to the market that what we really want is more vibrant competition to both reduce prices and improve innovation.
You mentioned Amgen, Horizon. I think we saw a big drop off in that type of merger, which is effectively a monopoly drug is coming off patent and is getting bought at a premium. What does that say about what the expectation is of whether or not that monopoly pricing will continue? Is that, do you think about that as, hey, like, yes, this is something we really don't want. We don't want people thinking they can extend their monopoly control over a drug. And you mentioned it almost sounded like killer acquisition, a catch and kill in healthcare. I think that's been really well talked about in tech, but not quite as much in healthcare. Do you see that? I mean, that's two questions in one. Sorry to do that to you, but
No, it's easy. I can
Yeah.
say yes to both of them. I think both of those things are concerns. Taking the latter first, we do. I think in all markets, we should look at what is the incentive of the acquirer. People talk a lot after acquisitions are proposed about the incentive to build out a product and bring it to market and do investment in it. And that may be true in some cases, but sometimes it's an after developed narrative, and going back and figuring out what was actually the incentive. What did the companies really want when they brought this drug? I think the question about extending the life of a patent goes to the same sorts of issues we're looking at with things like Orange Book listings or patent thicketing or other ways in which companies want to, for very good reasons, right, profitably extend monopoly rights. That the incentive there is very clear and understandable. That doesn't always make it legal. And so making sure that we are understanding what's happening in order to challenge conduct where it is illegal. And sometimes it's not illegal but it is under scrutinized. There's not a lot of transparency. Pharmaceutical markets and the pharmaceutical payment system has an enormous amount of opacity and complexity that takes a long time to unpack and dive into and understand. And I think one of the things the staff at the FTC does exceptionally well is that hard work of understanding and unraveling what is going on in these markets, so that we can do the necessary scrutiny.
one thing that the FTC has done during the Biden administration a lot is these 6B studies. I give an example of something I'm interested in learning about, and my question ultimately is, or do you see this interest in 6Bs and in-depth studies continuing? But like you mentioned, this catch and kill situation in pharma mergers, it actually would be really nice to know, hey, how often is it that when one of these drugs gets acquired, one of these innovative drugs gets acquired, does it get discontinued as opposed to like invested in, which is, the story we always hear is, oh, we're going to throw lots of money into this. And then you start to realize, well, you've got this maintenance drug, and this is actually would be a cure, and like your revenue stream you have all these very perverse incentives in the way that the pharmaceutical industry currently operates. And, I'm curious if 6B and focus and in this industry in particular lends itself to continuing that work. Or
Yeah, I think the 6B authority is an incredibly valuable tool for the FTC and for the public. I think our ability to provide information to the public about what is happening in markets is a huge, huge benefit. It's also really hard. Uh, Doing 6B studies takes a lot of work, it takes a lot of resources. Um, we have the legal authority to compel production. Sometimes people who get orders for compelled production do not feel interested in providing that production, and so making sure that companies know that we will use the tools that we have is really important, and I think that's something that we've done very well. I think it can be hugely valuable and is something we should continue to build on to develop internal expertise, provide public transparency, and it is not a substitute for enforcement. I think that's also really important to be clear about. Sometimes markets that we study have patterns that suggest illegal conduct may be happening, and then we should do separate enforcement investigations. Sometimes that's not the case. Sometimes there are markets where we're like, well, this is problematic, but not illegal. And that's where transparency, I think, can be really helpful.
I'll ask one last question, then we'll turn it over to the audience. There were some really interesting consumer protection cases, enforcement, investigations when it comes to data, healthcare, privacy. Would love to hear how you think about the legacy there, your interest there, and how you see that going forward.
Yeah, this is a really important topic. I mentioned a little earlier the point about the crossover between our consumer protection authorities and our competition work. I think the area of privacy, including and perhaps especially health privacy, that's extra true. When companies are illegally collecting data in order to either build market surveillance or capture more market power, then they are committing consumer protection violations in order to gain a competitive edge. And that is a problem. And so it's something we need to look very carefully at. We've been very focused on the market for sensitive health data, the markets that exist for sensitive health data, and have developed and sometimes have developed in violation of the laws that we enforce. So we've brought cases against, for example, BetterHelp and GoodRx, which did use sensitive health information to do targeted advertising in a way that violated the law. And I think we're going to continue to scrutinize things carefully in this area. I will also point out that when Amazon completed its acquisition of One Medical, the commission issued a unanimous bipartisan statement, and that was important because it was in like February of 2023 when there wasn't a lot of unanimous bipartisan feelings happening at the commission, but a unanimous bipartisan statement that said just because this acquisition has closed consistent with the HSR Act and on the HSR timeline does not mean we will be indifferent to the potential consumer protection or data privacy issues that may arise when a very large tech company has acquired a medical practice that includes a lot of sensitive health data. And so I think sending market signals that we are going to look across the agency at how data is used in a competitive way is something that is really important. And again, I think an important area for bipartisan agreement going forward.
Do we have any questions in the audience? We've got a number here.
Thank you. At a panel earlier this morning, I think some of the panelists expressed a little bit of doubt or hesitation about how the incoming administration might interpret Section 5 of the FTC Act and unfair practices, and whether that'll be the same as it has been under Lena Khan. Do you see, I think, this interpretation of Section 5 is kind of crucial to the work you've mentioned so far in this chat? And I guess how, if anything, do you think a different interpretation might impact the cases that the FTC is able to bring forward over the next 4 years?
Yeah, it's a great question. So I'll go back. The Section 5 policy statement that we issued was issued before either of the sitting Republican commissioners had joined the FTC. So they haven't had an opportunity to opine on it directly, including our incoming chair. So I don't want to speak for them. I don't know how they particularly feel about it. I do know that that statement ran in very detailed way through the text structure and history of Section 5, and that I feel very strongly that our job is not to aspirationally say what we wish was in statutes. Our job is to faithfully execute the statutes that Congress has passed, and that includes Section 5, which includes purposefully broad language. Incoming Chair Ferguson has talked a lot about the importance of being faithful to congressional statutes and not reinterpreting them on our own. And so I think that it would be consistent with that directive and a view of deference to Congress to continue to give Section 5 the independent meaning that Congress gave it. And I think that that is an important tool that we can and should continue to use.
I want to ask one quick follow-up question, and then we've got two questions in the front here. States have a lot of states have a Section 5 like authority. And the FTC worked a lot with states, and in bringing enforcement. We saw with Kroger Albertsons not just a federal lawsuit, but separate state lawsuits as well. And that, do you see continued work with the states, and the Section 5 legacy as not just for the FTC, but also a bit of a roadmap for how states could use it?
Yeah, for sure. I mean, I think there are two scenarios. Either we can continue to partner with states in moving this important work forward, or if the FTC takes its foot off the gas, which I hope it will not do, the states can pick up some of that work using the tools that they have. We have, as you say, similar, sometimes more similar, sometimes slightly different tools, and the states have been really innovative in using those effectively, and it's been impressive to watch, and I'm excited for it to continue.
We got two questions here in the front.
What do you think?
Do the mic? No? Oh, sorry. Let's go with the mic first. Sorry.
Yeah, I'd like to know whether the FTC and HHS joint investigation on the role of group purchasing organizations is going to survive, in connection with drug shortages, is going to survive the Trump administration.
I am the wrong person to ask that question to, since I will be in the minority. Again, I think that work that is pretty obvious on its face, and I think here you're talking about an RFI rather than a request for information, rather than a particular enforcement investigation. That was issued almost a year ago, I think, the RFI that you're talking about, and so information. It would seem weird to me to let that information, if it's been collected, die in a void. But I am not going to be the key decision maker on that.
We had one point made earlier that the president, in an interview recently, the incoming president, Trump, said that he had a problem with drug middlemen. He was talking about PBMs, but ostensibly that would also theoretically apply to GPOs as well. Last question here.
What impact do you think the overruling of the Chevron decision will have on the work of the FTC?
It's a really good question. So I think it's important to look very carefully at what the decision said and didn't say. It did not say agencies can't do anything. And I think it's sort of been interpreted as having said that. That is not what it says. What it says is that when courts evaluate agency action, they will evaluate it independently against the text of the statute, not starting with deference to the agency as long as it's not in contravention of the statute. In my mind, that's how we do our work already, right? We look at the text of the statute, we figure out what our tools are, we try to apply them faithfully. So I don't look at the things that we do and say, well, this has a lack of Chevron problem. And I don't start from a premise that we rely on deference in order to survive scrutiny. Obviously, that might be a litigated question, but the important standard, I think, for us to focus on is making sure that our actions are in line with and faithful to the text of the statutes that we enforce.
I want to ask one last question, which is kind of gets at the moment here, the sort of anti-monopoly moment in the courts. I think, at least over the past 4 years, when there's been the FTC and DOJ have been more aggressive in bringing cases that are ultimately litigated, the judges have been, I think, surprisingly open to, antitrust cases. I know there's like, theories out there that, the FTC lost a lot of cases and things like that. But from my standpoint, just judging all of the types of cases, the FTC and DOJ are winning a shocking number of them, given that they're self-selective. Only a few actually end up getting litigated. And there's just an openness by the judges, despite sort of a 30-year, 40-year consensus that, Chicago schools consensus on economics. Do you sense that? I mean, am I crazy to think that like the courts have become more open to antitrust enforcement, or do you see that as well? And has that changed your mind about the sort of opportunity when it comes to antitrust?
So I think two important points. Where I will disagree with what you said is surprised to see the victories. I have not been surprised, because when I have voted on the cases, it is because I think the law has been violated, and I think our litigators have the facts to back up those assertions. And we don't bring cases if we think the law has not been violated. So I'm happy when we win cases. I do not like losing at all, but I am not surprised, because I think if we were surprised by victories, then we shouldn't have brought the case to begin with. So I think you are also right that we have been doing a lot of winning. Kroger Albertsons this week is an important one. We won the Tapestry Capri preliminary injunction. We won the litigated preliminary injunction in IQVIA last summer. We won in the US Anesthesia Partnership, the PE roll-up case. We won the motion to dismiss against against USAP. Amazon lost its motion to dismiss on our larger conduct lawsuit. Our Meta case is going to trial next year, survived a motion to dismiss. I mean, there's a lot of winning. And thank you. And I'm really proud of that. And really what I want to say is I'm extraordinarily proud of the work that the staff has done in these cases. They get up against usually 3 to 4 times as many litigators who are paid more than 3 to 4 times as much as them, have much more in terms of resources and support, and they just focus on the facts and they focus on the law and they lay out the cases. And I think that is why they win, because that is what they are relying on. The point that you made that I think is an important one is the self-selection point. You miss all of the shots you don't take. If we aren't bringing litigated challenges, of course there isn't going to be as much success in the courts. So you have to bring them. We have to bring them only where we think the law has actually been violated or will be violated. But we are bringing more litigated cases. And I think we are doing that in part because we are evaluating whether potential remedies, non-litigated remedies, will actually be effective to protect competition. And where they won't, there's not a lot of benefit to taking them. And that is where I think we're on the strongest ground going into court.
Thank you so much for doing this today.
Thank you.
Yeah, we're going to break for lunch, 30 minutes, and then we'll get the rest of the panels. Thank you so much. That was amazing.